The irony was staggering. One day after a former FBI director was arraigned for lying to Congress, the Attorney General sat in that same chair and made demonstrably false statements to this very committee. Senator Whitehouse methodically exposed each lie with receipts. The DOJ thought nobody would check. What happened next left her speechless and should terrify every American who believes truth matters in our justice system.
Here's the second thing, and this goes back to the ranking member's comments about yesterday. To me, yesterday was an awful day in the history of this committee. It set new low after new low after new low. And I'm not going to talk about all of the new lows. I'm going to talk about one in particular. And that is whether anybody noticed the irony that the day before the United States Department of Justice arraigned a former FBI director for allegedly making untruthful statements to this committee, the Attorney General of the United States sat right there and made untruthful statements to this committee. And they weren't maybe untruthful statements. This wasn't a question of nuance. She made allegations about the ranking member and me having received political contributions from some, she said, Epstein close confidant. Well, guess what? That's actually checkable. There's a thing called the Federal Election Commission. The Federal Election Commission keeps a website that tracks all of our contributions. An intern at the Department of Justice could have checked to see that the allegation, I'll leave it to myself, that I had received campaign contributions from this individual, that was false. And it's not a maybe answer. It's a yes or no. Did I or didn't I? And there's an unimpeachable record that shows that what she said sitting right there was not true. If we are going to care about untruthful statements made by the Department of Justice and the FBI in this committee, let's not have this be yet another area where there are different rules for one party than for the other party. And just by the way, on that very subject, the other thing that the Attorney General did sitting right there was to strip all cover away from the untruthful statements that had been made to this committee by the current FBI director. You all heard him here. He said that he couldn't tell us about his grand jury testimony in the Mar-a-Lago case, where he first pled the Fifth, then got immunity, and then testified. He couldn't tell us what he testified to, he said, because the Department of Justice had sealed the testimony and because there was a court order barring him from doing that. And he actually identified which judge, the chief judge of the D.C. Federal District Court. Well, guess what? We know that since then, the chief judge of the Federal District Court has said that that was not true. He said specifically nothing prevented Director Patel from discussing his grand jury testimony. And yesterday, the Attorney General had the chance to say, you're right. We did seal the testimony in that matter. The Department of Justice did seal the testimony, and Patel's statement was true. Not about the court order, but at least it was sealed by the Department of Justice. She didn't say that. So now both his testimony that the DOJ had sealed his testimony and his testimony there was a court order barring his testimony are kind of demonstrably false statements to this committee. And then when he came back and we challenged him on those false statements, his second false statement was to say, I'm not going to answer any of those questions because my transcript of the grand jury testimony, I've worked with the DOJ to see that it is publicly released. Well, it either has been publicly released or it hasn't. It's a very simple distinction, yes or no. And we all know that it has not, in fact, been publicly released. And when we asked about that from the Attorney General, again, she left him high and dry and refused to say that anything had been publicly released, that there was any publicly released transcript. So yesterday stands in really stark contrast. I should say the day before yesterday stands in really stark contrast to yesterday. Yesterday, an FBI director was arraigned for making a false statement. The day before that, the Attorney General of the United States made arguably even falser statements. We'll see how the other case turns out. And she left the current FBI director completely exposed on his multiple false statements that his grand jury testimony in the Mar-a-Lago case had been sealed by the department, was under court order not to be released, and had since been publicly released as a transcript. I don't know if this committee is going to take itself seriously enough to treat false statements to this committee as serious matters, irrespective of who made them. But the contrast is really stark. Thank you, Chairman.
What Senator Whitehouse delivered wasn't just a speech, it was a masterclass in institutional accountability that exposed something far more dangerous than garden-variety political spin. He systematically dismantled a pattern of false statements that strikes at the heart of how justice operates in America. The backdrop makes this moment even more explosive. Just one day after a former FBI director was arraigned for allegedly making false statements to Congress, the current Attorney General sat in the exact same chair and made what Whitehouse characterized as demonstrably false statements to the same committee. The irony wasn't lost on anyone paying attention. Whitehouse focused on something most people don't realize can be easily verified: campaign contribution records. When the Attorney General accused both Whitehouse and the ranking member of receiving political contributions from an Epstein confidant, she made a claim that could be fact-checked in minutes. The Federal Election Commission maintains public records of every political donation. An intern could have verified this information before the hearing. But she didn't check, and the records show her accusation was categorically false. This isn't about political theater or partisan point scoring. When the nation's top law enforcement officer makes verifiably false statements under oath to Congress, it creates a crisis of credibility that ripples through the entire justice system. If the person charged with ensuring truthfulness in federal investigations can't maintain basic accuracy in her own testimony, what does that say about the department's commitment to truth? The Patel testimony issue reveals an even deeper problem with institutional integrity. Patel claimed he couldn't discuss his grand jury testimony from the Mar-a-Lago documents case because of DOJ sealing and a court order from the chief judge of the D.C. Federal District Court. But that judge later clarified that nothing prevented Patel from discussing his testimony. The Attorney General had the opportunity to clarify whether DOJ had sealed the testimony, providing cover for Patel's claims. She didn't. Instead, she left Patel exposed on multiple false statements about grand jury proceedings, court orders, and public releases of transcripts. When pressed on whether his transcript had been publicly released, Patel gave another demonstrably false answer, claiming it had been when everyone knew it hadn't. This pattern reveals how institutional protection works when it breaks down. Career prosecutors and agents rely on clear, consistent guidance from leadership about legal boundaries and disclosure rules. When that guidance is contradictory or false, it creates confusion that can paralyze investigations and erode professional standards. The real danger isn't just these individual false statements, it's the precedent they set. When truth becomes optional for those charged with enforcing it, the entire framework of equal justice under law begins to collapse. Prosecutors start making decisions based on political calculation rather than evidence. Agents hesitate to pursue leads that might displease leadership. Citizens lose faith in institutions that should be above partisan manipulation. Whitehouse's methodical approach, citing specific sources, demanding yes or no answers, pointing to verifiable records, represents how oversight should function. He didn't rely on speculation or innuendo. He used the Federal Election Commission database, judicial statements, and public records to expose falsehoods that anyone could verify. The silence that followed each of his factual challenges speaks volumes. When confronted with documented evidence of false statements, neither the Attorney General nor Patel provided clear corrections or explanations. That silence isn't just awkward, it's institutionally corrosive. This moment should force a broader conversation about accountability in federal law enforcement. If we're serious about preventing false statements to Congress, those standards must apply equally regardless of party affiliation or political convenience. The contrast between arraigning one official for false statements while ignoring others undermines the principle that no one is above the law. What Whitehouse exposed wasn't partisan gamesmanship. It was a fundamental test of whether our justice institutions will remain credible and effective, or whether they'll become tools for political protection rather than equal enforcement of law.